So, let's talk about jurisdictions, folks. Now, say you do have to go to court. You step into the courtroom, they want you to plea. Are you guilty or not guilty? In the words of Carl Miller, I would like to plea in the form of a demurrer. A demurrer is a jurisdiction, a type of jurisdiction challenge is a demurrer, and a good way to do it, like Carl Miller talks about a lot, but I like how Howard Freeman talks about it more, because the courts don't always abide by the laws. Well, actually, they never abide by the laws, period. They do whatever the fuck they want with made-up laws that fucking contradict supreme laws. Anyways, Howard Freeman's technique was to ask the judge to play stupid. That's the best thing to do, play stupid. Ask the judge, Your Honor, for the record, can you please state the jurisdiction? And sometimes it's best to, I think, before you ask them that, ask them, did you take an oath to the Constitution? Most of the time, any officer of the court or officer in general will be proud to say that they took an oath to the Constitution, even though most of them didn't. They didn't specifically take an oath to the Constitution, but anyways, they'll lie to you and say they did. But then they get this pride, and then you're like, just like when I used to walk around and skate at night, Sir, why would you want to violate your oath to the Constitution by violating my Fourth Amendment, which is protected by the Constitution? Didn't you just say you took an oath to that? Anyways, so Howard Freeman's, one of his simple techniques for traffic tickets, for example, was to specifically, get the court to say, this is a criminal jurisdiction. He'd get them to say that on the record, and once it's on the record, there's no arguing. So you get them to say that, then tickets these days, they don't say civil infraction on them anymore, but they used to say it right on there. I mean, I don't even know what a speeding ticket looks like these days because it's been so long. Anyways, so in these jurisdiction arguments, depending on what jurisdiction they say on the record, you have to have an argument for each. No matter what answer they say, there's only about 3 to 7 answers they can say, where typically they'll say it's a criminal, civil statute, criminal statute jurisdiction. It gets complicated when you start arguing with them. Most of these people have no brain. They just do what they're programmed to do. But anyways, in the long run, one of Howard Freeman's arguments is about, I forgot how he sets the argument out, but it's about an international contract in question, in controversy. And in the long run, in the courts, I mean, that argument, which is really hard to explain, but, he'd bring that up, and then, well, show me the contract, show me where I signed it, where I'm a party, blah, blah, But, like, it's fucked up. The jurisdictions are, when I made jurisdiction arguments in child court to try to get my kid, they were like, oh, it's child court jurisdiction. And I'm like, well, is it a criminal or civil? And they just kept saying child court. And it's like, okay, well, there's no official rules there's no public records. There's no accessible public rules of procedure in that specific jurisdiction, and thus limiting my ability to pro se litigate in my own defense. I can't litigate when I don't know the rules and regulations of the court of this hidden jurisdiction, and which violates your right to be your own attorney. And that's protected by the Sixth Amendment right. And when they do that, when they violate your right to be your own attorney, it's actually a crime. And I didn't know it at the time, but I could have pressed, and I still could, but I know the fucking police won't press the charges. But they violated my rights under the color of law. They committed the crime of deprivation of rights under the color of law, which is a felony. And there's no statute of limitations on that. So I could go to the state police and press charges on these fuckheads whenever I want. Because the other statutes of limitations have ran out, like the statute of limitations for perjury, which the CPS lady did to me, that ran out. That ran out like a couple of years ago, because that's a 7-year limitation. But anyways, not that they would even press the charge. I even tried pressing the charges. The fucking popo wouldn't press the charges. Why? Because they fucking don't give a fuck. All these people claiming wearing suits, never trust a person with a tie. Fuck them. Trust the blue collar. Blue collar, holla. Anyways, the whole idea of the courts, they were blended in 1938. The civil and the criminal jurisdictions were blended together, but they don't want you to know that. Ralph Epperson talks about it. Which Ralph, I agree with almost 100% of what he says with legal standpoints, except the fact that he doesn't understand the 10 square mile clause and how it limits government and how they're violating it. And because when it says Congress has the power to legislate in all cases whatsoever within the 10 square miles, and fucking Ralph's like, oh, it has unlimited power everywhere. And it's true, because they have violated the 10 square mile clause and spread their jurisdiction throughout all the states. But if the 10 square mile clause was being enforced, then that statute would have limited power. As in that they can't just do whatever the fuck they want. Anyways, back to the constitutional arguments. Let's talk about the Second Amendment argument. There is no argument. Why? Because the Second Amendment, Lake County versus Rollins, the government, they are not at liberty to reach for definitions beyond the instrument. Damn, my nose is running. I got allergies. The instrument is the Constitution. They, the government, cannot reach for definitions beyond the Constitution. Show me in the Second Amendment where it says acceptable forms of infringement, because it lists none. And when it lists none, there can be no infringement. The Supremacy Clause, Marbury versus Madison, Lake County versus Rollins. They can't define the Constitution beyond the means of the instrument. It says shall not be infringed. There is no fucking argument. None. No fucking argument. All these fucking gun nut, anti-gun nut fucking idiots, they don't understand the Supremacy Clause. They don't understand the law. They don't understand Marbury versus Madison. Anything in conflict is null and void in law. The courts, anybody with a fucking name tag is a fucking idiot. Not counting employees of stupid. Anyways, the same thing pertains to the First Amendment, the Fifth Amendment, Fourth Amendment, all the amendments. They cannot be violated, but yet they're violated on a daily basis. Why? Because we don't have a constitution. It's all a fucking smoke and mirrors. We need our constitution back. Otherwise, we're fucked. You wanna believe in God and blah, blah, blah. I'm not saying I don't believe in God, but I don't fucking adhere to fucking books and all this other bullshit. You're not gonna have a right to believe in what you wanna believe if there's no constitution. If there's no fucking limiting factor to the power that controls everything, which the founding fathers specifically, everybody wants to demonize the founding fathers because they don't know how to fucking read. They're illiterate. They never read the Constitution. Oh, the Constitution is a tired old document. Oh, I don't understand it. And it's like, if you don't fucking understand it, if you've never read it, if it's too complex to read, then you're a fucking idiot.